and I'd like to welcome you to tonight's panel discussion. The topic is, should political belief and association be protected by Canadian human rights law? Before we begin our introductions of the panel, I'd like to acknowledge that the land on which I'm speaking to you tonight is the territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit, and the Williams Treaty signed with multiple Mississauga and Chippewa bands. In addition, I'd like to thank the co-sponsors for tonight's panel, and they are the British Columbia Civil Liberties Association and PEN Canada. We really appreciate your co-sponsorship. Well, human rights laws for Canada, the 10 provinces and the 3 territories, provide protection for discrimination on a number of grounds, including religious beliefs. There is no consensus whether political affiliation and political beliefs should also be protected. Some jurisdictions do in Canada and some don't. Why is that? What are the issues that cause some to embrace broad protection for political belief, some to provide limited protection, and some no protection? Today, the Center for Free Expression is bringing together a diverse panel of Canadian experts on human rights law to explore these questions, which have become even more important at this time when political beliefs are so central to every aspect of our lives and in which society is so polarized politically. So let me introduce our panel. First, I'd like to introduce Birju Dattani. Birju is a senior fellow at the Center for Free Expression. He's formerly the executive director of the Yukon Human Rights Commission. He, before that, was director of human rights and conflict resolution at Centennial College and an assistant regional director of the Alberta Human Rights Commission. Even before that, he taught law in the Faculty of Law at the School of Oriental and African Studies at the University of London, where his teaching was in international comparative law, human rights law, and European law. Welcome, Birju.
Hi, Jim. Good to be with you.
Our second panelist is Abby Deshman. Abby is a lawyer at St. Lawrence Barristers. But for the last while, she's had another job as well. She's the Interim General Counsel and Executive Director of the Canadian Civil Liberties Association. Abby is quite a talented and active lawyer. She's litigated at all levels of courts in Canada, from Supreme Court of Canada to Ontario Court of Appeal, Ontario Superior Court, and the Human Rights Tribunal of Ontario. Earlier on, she was a senior policy advisor for the Minister of Community Safety and Correctional Services. Welcome, Abby.
Thanks, lovely to be here.
Our third panelist is Michael Gottheil. I think it's safe to say that there are few people in the history of Canada who can match Michael's long and impressive career as a tribunal chair, a mediator, a lawyer, and an advocate. Amongst the positions he's held in the past was Chief of the Commission and Tribunals at the Alberta Human Rights Commission, Executive Chair at the Social Justice Tribunals of Ontario, Executive Chair of the Environmental and Land Tribunals of Ontario, Chair of the Human Rights Tribunal of Ontario. Michael is also blind and has very deep roots in the disability community. It's an honor to have you with us tonight, Michael.
Thank you, Jim, and thanks to the Center for inviting me.
And our final panelist is Michael Link. Michael is Professor Emeritus of Law at Western University. He's a labor arbitrator and mediator, and presently he's an arbitrator with the Ontario Grievance Settlement Board. Michael's published widely on Canadian labor law and human rights law. In 2016, the United Nations Human Rights Council unanimously selected Michael for a 6-year term as the 7th Special Rapporteur for the human rights situation in the Palestinian Territory. In that capacity, Michael regularly reported on human rights trends in the occupied Palestinian Territory to the United Nations General Assembly, to the Human Rights Council. Michael's scholarship and UN reports have been widely cited by courts, tribunals, scholars, and human rights organizations around the world, including the Supreme Court of Canada, the International Court of Justice, and the United Nations General Assembly. Welcome, Michael.
Thank you very much for having me, Jim.
And finally, our moderator for this group, is Faisal Baba. Faisal is an associate professor at the Osgoode Hall Law School, where he teaches constitutional law, human rights law, legal ethics, and appellate advocacy. Faisal is the former vice chair of the Human Rights Tribunal of Ontario. He's a senior editor of the International Review on Human Rights Law. And while doing all this, he maintains a law practice in which he represents individuals and public interest organizations in matters pertaining to constitutional law and human rights. Welcome, Faisal.
Thanks, Jim. I'm delighted to be here.
Well, we're delighted to have all of you with us tonight. I'd just like to explain to the audience that the panel is going to have a conversation for 45, 50 minutes. And if questions come to your mind that you'd like to add them, because at the end of that conversation, we're going to then have a half an hour or so for a Q&A with the audience. You'll see at the bottom of your screen a little, it's a little square that has a question mark in it. Below it says Q&A. So if you click on that, you can write out a question. And when we get to the audience part of the event, Ange Holmes, this coordinator for the center who's monitoring the questions that come in, Faisal will turn to her and ask her what's the first question. She'll read it out, the panel will address it. So I just encourage the audience, as you're listening to our panelists and a question comes to mind that you'd like to ask one of them or like to ask several of them or all of them, just click on that Q&A button, write out your question while you're thinking about it, and then we'll get to it when we come to the Q&A part. Other than that, I'm really looking forward to your conversation and discussion. Over to you guys.
Thanks, Jim. I'm very excited to be moderating this panel of distinguished panelists who each one of whom brings their own unique perspective, and I think we can be assured of a lively discussion. Now, what's the discussion going to be about? What's it going to pertain to? The title of the event signals a series, really, of questions that we'll be looking at. What is the status of political belief or political opinion, political expression, discrimination in Canada? And I mean, first of all, what are we talking about? Political belief, political opinion? What's the difference? What do these concepts mean under Canadian law? How do we understand political? How do we understand a belief? How are beliefs and opinions different from words expressed? And how do these concepts, political belief, relate to constitutional concepts like freedom of conscience, freedom of expression, or freedom from, or how are they distinguished then from other constitutional concepts such as freedom from religious discrimination? So all of this is kind of in our landscape of law and raises a whole bunch of questions that really have not been adequately answered by the courts and are certainly not consistently answered by courts. And so we'll hear from our speakers about the state of the law. And we'll also hear about the possibilities of the law and of institutional design to give life to the law, because there's one question about the existence of a category of protection under the law, and there's a series of questions then that flow from that about the extent of meaningful recognition of that right, should it be recognized. And I think we'll hear a little bit about risks of unintended or possibly intended consequences that present threats of a different sort to that right or to other interests that underlie the right. So there's a lot to unpack here, a lot of questions. We also face in Ontario a sort of a paradox in the sense that with all of these unanswered questions, there's this apparent rule from the Ontario Court of Appeal, a 35-year-old rule that tells us that there is no political opinion discrimination under the Human Rights Code, and that it is not within the meaning of creed, the category creed, which is a unique category in Ontario's context. But I expect we'll hear something about that, because the question is, how stable is this rule that most lawyers practicing in Ontario today would have been educated over the last 35 years that this is an established precedent that cannot be overcome, and courts have certainly applied it as such. So having sketched at least my own kind of different pathways of interest into this topic, I'm going to turn it over to our speakers to each answer an initial introductory question that I'm going to put to them in the hope that we can begin to unravel this tangled mess of political belief or political opinion discrimination in Canada. So we're going to start with Michael Link. And I'd like to ask Michael if he could lay the landscape for us as the resident law professor on the panel. What is the status of political belief protection under anti-discrimination law in Canada today?
Faisal, thank you very much for that. We think of when we think of human rights, and particularly across the 14 jurisdictions in Canada, the 10 provinces, the 3 territories, and the federal government, there are some concepts like race or sex or sexual orientation or disability that are in every one of the 14 human rights codes or acts across this country. That's not so with political belief or expression or opinion. And I think that's what we're going to try to digest today. So I've got 6 points I want to lay out as an introduction to telling us what the landscape really looks like. So number 1 is we have protection in 9 of the 14 human rights statutes for, and it's for political belief or expression or opinion. It's got different titles in different jurisdictions. So the 5 jurisdictions that don't have any protection at all are Ontario, the federal government, Saskatchewan, Alberta, and Nunavut. And of the 9 others, some give it a broad definition, some get a very narrow definition. I'm going to allow, I think Abby is going to be the one who's going to take us through what the specific differences are in the jurisdictions. But this means we've got one of the most confusing areas with respect to human rights law in terms of its protection. As I said, some provinces don't, some jurisdictions don't cover it at all. Some cover it in a very broad way, some cover it in a very narrow way. The second point I want to lay out for us is that the Supreme Court of Canada has made a number of rulings over the last 40 years or so on human rights law in Canada. And generally, they've done a very good job of telling us how we're supposed to approach human rights. Human rights are supposed to be interpreted in a broad and liberal fashion, and they're supposed to be interpreted all the same in the same broad and liberal fashion. And exceptions to human rights or limitations on human rights are supposed to be interpreted narrowly. So let's keep that in mind as we start to discuss in more detail and get into the weeds with respect to political expression, opinion, or belief. The third point I want to raise is that protection for political expression or political belief has a very strong anchor in international human rights law. We see this right from the beginnings of the 1948 Universal Declaration of Human Rights, and we also see it in the 2 1966 covenants on human rights, the International Covenant on Political and Civil Rights, and the International Covenant on Social, Cultural, and Economic Rights. And the Supreme Court of Canada has said on a couple of occasions that when we're interpreting the Charter, and also probably in the background when we're interpreting human rights law as well, we have to keep international law in mind. We have to keep, I guess, an ongoing symbiotic relationship between how we practice constitutional rights and human rights in Canada on the one hand, and how we're to link that or draw inspiration and interpretation with international human rights law as well. My fourth point is a bit of a sideways point. It's that we do have protection for freedom of conscience and expression in Section 2B of our Charter of Rights and Freedoms. And this tells us 2 things. First of all, the application of the Charter of Rights and Freedoms, when it comes to employment, which is our central focus today, really only applies technically to state actors and therefore the employees of state actors, municipal governments, provincial governments, federal governments, school boards, for example, or special agencies of any level of government. So those employees wind up having, if you like, a extra degree of legal shelter that employees working for non-state actors, which is probably 3/4 of the workforce, don't necessarily have. But my second point with respect to freedom of expression and conscience is that the Supreme Court of Canada has developed this concept, not really well defined, known as charter values. And that tells us that even though the Supreme Court of Canada may make a specific pronouncement on how broad freedom of conscience or freedom of expression may be within state actions or state actors, is that interpretation is supposed to extend beyond state actors, and it's supposed to, if you like, inform the rest of our laws, including human rights laws that may wind up pertaining to employees in a private employment relationship. So that's another important thing to keep in mind. My fifth point of 6 is collective agreements. And I think it's important to lay out that the 30% of the Canadian workforce that are covered by where they belong to unions and are covered by collective agreements, there are, if you like, special rules that apply to them, which impact upon their, if you like, their right to political expression. And what the arbitrators who arbitrate differences between employers and unions under collective agreements point out is that there seems to be a little bit of extra protection for employees where they may make some off-duty comments or they may be critical of their employer. There is a balance that arbitrators recognize between political expression on the one hand, or political criticism, perhaps of their employer or of some other event, and on the other hand, the public reputation of the employer. And traditionally, that's usually been weighed in favor of the employer, where there is a great deal of emphasis put by arbitrators with respect to protecting the reputation of employers. That, I think, that balance is beginning to change as we grow perhaps into a more contentious area or period of time, and where there's a greater recognition of the breadth of freedom of expression and how that would apply in a collective agreement. And my fifth and last point simply is this, is that there was a very famous case back in the 1990s called Vereen versus Alberta. And that ruling from the Supreme Court of Canada, I think in 1998, said that sexual orientation at the time was not in 2 of the 14 human rights statutes. It wasn't in Prince Edward Island and it wasn't in the Alberta human rights legislation. And the Supreme Court of Canada said that's under-inclusive. And Vereen now stands as a potential pathway for particularly those provinces or jurisdictions that I mentioned earlier on that don't expressly protect political expression or opinion or belief in their human rights statute, to challenge that under the Vereen rule with respect to under-inclusiveness. So I just lay that out as a possibility. But I hope that gives, in a very efficient way, in a legalese way, what the landscape is with respect to the protection or non-protection of political belief, expression, opinion in Canada.
No doubt, Michael. Elegantly laid out. Let's turn to Abby for some observations on the issues of scope with respect to the extent or this mishmash of protection. I mean, what exactly is protected? Where are some of the gray zones, and where can we expect to see perhaps interesting areas of development?
Yeah. And so I'll focus on the human rights legislation because it really does vary across the country. And so leaving aside for a minute the jurisdictions that have no protection for political beliefs, expression, etc., even in the ones that we do, there's a variety of interpretations and levels of protection. So you see everything from on the sort of narrow end of the scope of the protection. You're looking at PEI in New Brunswick. And those jurisdictions, in order to claim for discrimination on the grounds of political belief, you really have to show you are a member or an active participant or a contributant to a registered political party. So really talking about very formal lines of alignment with the very traditional democratic machinery. Then you've got a bunch of provinces, and in the past it was also BC. I'll talk about BC in a minute, but you do have some provinces that are sort of in the middle of protective scope. So, for example, Manitoba, you're going to get protection for political beliefs if you're focused on a political object or some type of discourse about what society should look like. So it doesn't have to be aligned. I've got the sun coming in. It doesn't have to be aligned with the political partisan machinery, but you do have to sort of be talking about, how should society be organized, sort of big picture things. It's not just any issue or topic that you're going to get protection on. And then BC, I think, is sort of the high watermark of the scope of protection. There's a 2016 case that said what BC protects is public discourse on matters of public issue that involve or would require action at a government level. So, when I hear that, like what public interest issue does not in our society involve government action at some level? That really is a very broad protection that's going to apply if you just take that line to a whole bunch of different political beliefs. And I'll say, my favorite question on this stuff is always, what should the law be? Like, what do I want the law to be? What should we want the law to be? And it's a pertinent question because I am, jurisdictionally in Ontario, where we don't have this included in our human rights code. And I really think there's pros and cons to each place that you situate yourself on this scope. Right? So if you think about the narrow scope, where you're really focusing on political parties and affiliation with political parties, that seems like a pretty poor, thin vision of what political opinion and action is, right? It's not going to include a whole bunch of the really robust, meaningful discourse and engagement that we have in our society. It's not going to include grassroots groups, social movements that aren't affiliated with political parties. There's a lot of expression that's going to fall by the wayside. And it privileges a colonialist structure of politics. And I think it's really interesting to me that the case that broke this open in BC and moved BC away from this narrow vision was an Indigenous person who was expressing political beliefs on First Nations governance, right? So really clearly crystallizes that really narrow scope is privileging older forms of power. But I will say there is some logic to this, right? So if you go back to the international law and why it was in the Universal Declaration of Human Rights in the beginning, they were focused on autocratic governments. They were focused on repressive governments that were persecuting and pursuing individuals and really, in very targeted ways, undermining those democratic foundations of the democratic machinery. And I think we take, the right to vote and democracy for granted, but perhaps less these days as we're watching really autocratic leaders very systematically pursue political opponents and undermine some of the foundational pillars of a really traditional democratic system. So I actually do think that there is, for me at least, today, there is still resonance in providing that very focused protection that can be quite different from what we would imagine when we're thinking about protecting political beliefs in an employment setting, for example. And then on the other side, when you think about broad protection, I personally get a little nervous there too. Because, as a free expression advocate, I spent a lot of time advocating against overly broad, vague legal restrictions on speech. And this means that I end up saying, yeah, we shouldn't have laws bringing down the hammer on speech that I personally find repugnant and offensive. But people should exercise their freedoms responsibly. And I do think there should be some consequences if people spout very offensive, vile, racist views, for example, I think there are appropriate social consequences. It's actually, I think, part of my responsibility as a community member to come out and say what you're saying is wrong and I don't agree with it. And that's my own personal and I think a communal responsibility. But if we take sort of the high watermark vision of protecting political beliefs and expression in human rights codes, you might start to remove some of those social responses from the scope of what you can do. So BC protects political beliefs and expression in the employment context primarily and in trade unions, but there's other jurisdictions that protect it much more broadly in the provision of services and goods and contracts. And so you start to think of some of the things that communities do to respond to speech they find offensive and political views they find offensive, like boycotts, or encouraging people not to contract with certain companies, or if I own a bookstore, I'm going to decide what political texts I want and what I don't want in my bookstore. And so if you really start to provide robust protection for this type of expression, you do start to eat away at some of those private sector social responses that I think are important to maintaining the vibrant discourse and some of the checks and balances that we have if we live in a society where the government is not restricting expression. So that's just to say, I think it's complicated and a great issue for discussion, and I'm interested in hearing others' thoughts as well.
Okay, great. Thanks, Abby. All right, we're still laying the land here. I want to turn to Michael Gottheil for his perspective on the institutional landscape and limitations with respect to the expansion of human rights grounds. Michael.
Yeah, thanks, Faisal. Well, first of all, I have to give a disclaimer. Apart from the other things I've done, I'm currently senior counsel at Arch Disability Law Center, a legal clinic in Ontario. So I just want to say the views I expressed this evening are my own and not necessarily those of Arch. So I guess as Faisal said, I'm asked to speak about some of the institutional implications of adding political belief to the Human Rights Code in Ontario and in other jurisdictions that don't have it. So I guess I'll start with something really, really practical. And so as somebody who's been in a leadership position of a number of tribunals, including 2 human rights tribunals in Canada, there's every tribunal in Canada has, or almost all, have a backlog and delays and are woefully underfunded, right? And so, if you say, if you essentially set expectations, which I think this is what, in some sense, you're doing, and saying to the public, look, if you feel that you've been discriminated against because of your political belief, here's how you resolve that. And you file an application with the Human Rights Tribunal. And in Ontario, for example, it could take 2, 3, 4 years just to get a hearing, never mind a decision. So, we need to think about those practical realities. And from the institution's perspective, I recall when a recent discussion, when there was a recent discussion about adding hate speech back into the Canadian Human Rights Act. And, one of the fears, if you will, of the Canadian Human Rights Commission was like, we don't have the money to deal with this tranche of new complaints that are going to come. Not to mention, as we know and can imagine, hate speech is, to put it one way, is very emotional. It's an emotional issue. And quite frankly, adjudicators, staff, the tribunal has a responsibility to increase security. I remember when I was in Alberta, we used to get around the masking issue, during COVID, really vile and threatening calls and letters to the tribunal. So, adding this very the controversial and polarizing issue of political belief into a tribunal, has its challenges. Now, of course, you may say, and tribunals say, and it should be the case, that government shouldn't, give additional jurisdiction to a tribunal without providing it the resources, and that's absolutely true, but it doesn't always happen. It usually doesn't happen because the adding of a ground is really in response to public outcry. We want this, and it's easy for the government just to add it to the statute without providing the institutional support. So that's first thing I think from an institutional perspective to think about. The second one I want to talk about is to remember human rights tribunals don't have the same level of adjudicative independence or decision-making independence that, say, courts do. So tribunals, without getting into the administrative law concepts, are actually part of the executive. So when we think of government, you have the parliament, legislature, you have the judiciary, and you have the government, which is the executive, the prime minister, cabinet, and so forth. So the power of a human rights tribunal is actually enshrined in a statute, but actually delegated by the cabinet in that sense. So there are, when push comes to shove, the courts have often say, well, no, tribunals don't have the same kind of independence and constitutional protection of independence that the courts do. And that can have, pretty serious ramifications for people who are seeking to enforce fundamental rights in front of a human rights tribunal. So, beyond funding and the capacity to do its work, in terms of appointments of adjudicators at tribunals don't have the same level of security of tenure. In other words, judges are appointed on life tenure, can only be removed through actually a vote of parliament after a recommendation from the Canadian Judicial Council. So there is, really important and significant protections that judges have to be able to make decisions that aren't necessarily popular, and not to be swayed or influenced by the government in power. And again, this is critical for determinations of fundamental human rights, and probably even more so when you're dealing with political belief and political opinion. Why? Well, because people generally don't get, fired or discriminated against if they agree with government or the popular or populist viewpoints. It's the people who, and the views that are contrary and challenge government and government power, that there's attempts to restrict, and that's where you need the protection. And so, if you go to a human rights tribunal and the adjudicators think, well, if I make this decision, I might not get reappointed. Obviously there's concern. Now, having said that, I've been on the tribunal. Faisal was on the tribunal. Michael does, adjudication as an arbitrator. Generally, adjudicators and tribunal members are quite conscientious. They care about the work that they do. They want to follow, they want to, have their decisions upheld in court and so forth. But there is this issue of security of tenure. So those are the sort of the institutional considerations. I want to just mention one other thing that is sort of related, and hopefully we can talk more about it, is remember, even in Ontario, we do have like freedom of expression, freedom of opinion, political belief, political expression is a human right, right? It's protected by the Charter, as Michael explained, by international covenants. And so it is already a human right. The question is, do we think it is useful or strategic to include it in a human rights code so a remedy can be sought when it's restrictions involving the private sector, private actors? And the other thing I would say is I think we also, at least for political activists, and there's a question: do you want to hand over the decision of what's legitimate speech or political belief, over to the law, over to tribunals or even the courts, because the law generally follows, where social values and political values. It doesn't. Sometimes it does, but doesn't always lead. And so, I think for political activists, essentially, do you want the issue taken off the street and put in a boardroom for, as some people say, people in three-piece suits to decide what's legitimate speech? So I'll stop there and looking forward to a lively discussion. Thank you.
Excellent. All right, let's turn to our final panelist for the laying of the land. And Birju, if I could ask you to give us some examples of what this looks like in practice, and what does the jurisprudence, the evolving jurisprudence, look like in terms of political belief discrimination protection in Canada?
Yeah, so thanks for that, Faisal. I think I am likely the only person that was at a commission or jurisdiction where political belief association and or activity is a protected characteristic in the Yukon Human Rights Act, namely, and that protection or that protected ground, unlike British Columbia, was not limited to employment and or union membership, but it also extends to goods, services, accommodations, and facilities, in housing, in membership in professional, vocational associations, trade unionship, basically the whole spectrum of what we would call protected areas. That being said, we considered the jurisprudence from British Columbia to be highly persuasive, bordering on authoritative. And the reason for that is that the BC Court of Appeal is also the Court of Appeal for Yukon. And so you're often not going to persuade judges by, or you persuade them better when you throw their own law back at them. And then they tend to agree with what they said, the year before or whenever. But that being said, there's a BC case back in 2018 called Poser and Maple Ridge. And it's helpful because what the tribunal there did is it distilled 5 core principles that must be extant for political belief, association and or activity to be in play. And those five are just, like very briefly. Um, uh, Firstly, every case is determined on its own facts and circumstances, which is barely a criteria. That's just common sense. But two, political belief is to be given a liberal definition, not confined to partisan political beliefs, yet with reasonable limitations. So it's setting a floor and a ceiling, and you're going to notice this with the remaining three. Three, have a factual foundation, such as the nature of the belief at stake. The belief should have a reasonable level of cogency and cohesion to ensure that it is tangible. Four, it must be genuinely held. It shouldn't be a passing idea or position taken for convenience, and it should extend beyond personal interests. And lastly, it must be core to a person's concept of a system of social cooperation. That is, the belief should relate to a broader societal system or systems rather than narrow operational decisions. And so that's what Poser, in looking at all of the jurisprudence that came before it, and each one of those points has a case appended to it. And so the tribunal is saying, well, here's all the mishmash that came before us, and here's an attempt to crystallize most, if not all, of the elements that have to be present for this to be in play. So, for example, in 2024, there was a case called Duarte. And so Duarte had two issues. So he claimed that he was discriminated on the basis of political belief in two ways. The first was that he was vice president of a major union in British Columbia. And second, that he was strongly opposed to vaccine mandates, despite the fact that he had complied with them. And so BC said, well, it isn't enough just to be a member of a union to be considered pro-union. That's not a tangible political belief. So tell us more about your pro-unionism as a political belief, and he couldn't do it. And so that failed. It didn't go past conjecture. The opposition to vaccines was interesting because they said that could be a political belief based on those five criteria that I just set out. There just happened to be no evidence that the complainant had suffered any adverse impact as a result of his anti-vaccine activism, which he had engaged in for those that didn't comply. So he showed that it wasn't simply a personal interest, as evidenced by the fact that he was advocating on behalf of others who had lost, on some pay or benefits in the workplace for their failure to comply. So, and we've looked at that jurisprudence, and that's typically the approach that we would take. I think from the standpoint of the public that are making complaints on the basis of political belief, one of the things that's most interesting to note is people would regard political belief as operating as religious belief does, or maybe the way that disability does. I'm likely to look at this more in terms of people looking at this as similar to religious belief, insofar as if you demonstrate religious belief, there may be, as part of the accommodation process, a duty to exempt a person from something that they would ordinarily have to do in the workplace, let's say, or in our context in Yukon, in terms of service provision, like let's say dissecting a frog, you could be exempted from certain policies in the workplace in a way that you're not with political belief. So the BC case law would also use this expression that a duty to accommodate, when you're talking about political belief, is not a duty to exempt. You are still required to comply with workplace policies. And a lot of this was emphasized during the pandemic when people were seeking to depart from vaccine mandates, whether those were in private employment, public sector employment, or under specific types of employment where the risk was particularly heightened. I'm thinking now of doctors, nurses, LPNs, pharmacists, etc. So, and people would be shocked at the fact that they weren't somehow exempted from those things that they politically objected to. And then there's BC case law that drew this analogy of, well, you can disagree with, drug laws in the criminal code, or programs provincially seeking to, exempt certain amounts of drugs for personal use, like a safe supply. That does not absolve you of your ability to follow those policies or the law as it's currently constituted. And so it operates differently than, let's say, religious belief does, which is probably its closest analog in some respects. Which sort of reminds me of something there too. And so when we were dealing with this, like the amount of complaints that were accepted on the basis of political belief, and I looked at a number of them. I think I only ever accepted 2 in my entire tenure, which is hundreds of complaints, and of that number, more than a dozen invoking political belief, association, or activity. I think some of the things that I would flag, that being said, is firstly, what's interesting, at least in Ontario, is, and I know that Abby very graciously and generously gave us sort of like the national overview, jurisdiction by jurisdiction. And Faisal, you had invoked this 35-year-old rule, about there, not being like creed not encompassing political belief. And I think here's where there's really some confusion. So in Vesna, so the Vesna and Elections Ontario, which was decided in 2016, just to show you the sort of thing that, kind of lends itself to this opacity. The tribunal in Vesna noted the following, that the divisional court has stated that mere political opinion is not within the meaning of creed, and it refers to Jazayeri. And it says, in upholding the decision in Jazayeri, the Ontario Court of Appeal left open the question of whether or not a political perspective, such as communism, that is made up of a recognizable cohesive belief system or structure, might constitute creed. It then also says in the same paragraph that creed as interpreted under the code does not include one's political point of view. So note that you have a political point of view, which is not covered by creed. You have mere political opinion that's not covered by creed, but you have political perspective, such as communism, which may be covered by creed. And so it concludes that in the case, on the facts in Vesna, that it didn't fall within the exception left undetermined, in scare quotes. That exception left undetermined, I guess, is political perspective, not mere political opinion or political point of view. I mean, that almost strikes me as, if I'm being frank, higher level nonsense, in terms of what are the distinction between those 3 things? I mean, if I asked you, give me a synonym for political perspective, you'd likely say political point of view. And so it is a little bit messy, the landscape. I think one of the things, and this will be my last point just before we open it up to a wider conversation, one of the things that I did see as executive director of the Yukon Human Rights Commission that did bother me was the fact that officially on the last StatsCan survey, just north of 30% of the population of the Yukon was Indigenous or First Nations. And there are 11 what they call self-governing First Nations in the Yukon, meaning that they have their own level of government. And in Yukon, I would argue, at least in theory, Yukon offers the most robust legislative protection on political belief, association, or activity, insofar that it doesn't limit it to a particular political ground, such as in BC, or limit it in terms of certain types of partisan political activity, as Abby has walked us through. And so what would happen is if you were a non-First Nations Yukoner and you were kicked out of your house, let's say, because of your political beliefs, that would be a human rights complaint under the Yukon Human Rights Act. It is not a protected characteristic under the Canadian Human Rights Act. So it would lead to a system where people that were most likely to almost, well, would face discrimination as a result of that jurisdictional problem would be members of First Nations communities. So if you're not a member of a First Nation, you can argue, and I would argue, at least in Yukon, you had more and better human rights protections. You had a longer limitation period. That limitation period could be extended at the discretion of the director. None of those things are present. So that lack of harmonization of some places protecting this, others not, and others having a patchwork of protecting it kind of, is a significant problem, at least from where I sit. And of course, where I sit will determine where I stand. So I'm going to pause there, and let's open it up a little bit, perhaps.
Yeah, wonderful. Okay, thanks, panel. I want to give each panelist a chance to either respond or intervene in some way to something that was said by someone else on the panel, or to ask another panelist a question should they have one. So let's do a round of that. Does anybody want to jump in off the bat? Michael Link, go ahead.
I'll just make I think, a very preliminary point, which I think maybe wasn't expressed by any of us, but seems to be a common thread underlying all that we've been saying. I think there are two big issues that we have to confront with respect to political belief, expression, opinion in Canada. And one is, I think it probably is the view of all of us, that every jurisdiction should extend human rights protection in their governing statute to political opinion, identity, expression, or belief, or so on. And the second thing I take from what we're saying, and people can chime in if they disagree, is that the definition should have the same wide, broad, liberal definition of what it means to hold expression wherever it winds up being. Right now, we have only 9 of the 14 jurisdictions even have some protection. And as Abby has explained, that protection varies from a very narrow definition to a fairly wide definition. And that shouldn't be, I think, in our modern human rights legal system in Canada. It's not what the Supreme Court has directed us to wind up finding, that it's made the statement many times over that all human rights are indivisible and they should be given all the same broad definition. So I'm going to put it out there that that I think we were saying every jurisdiction should have protection for political expression, however it's called, and the definition should be the same. It should be broad and liberal.
So I'll say I'm not quite there. I mean, and this may just reflect CCLA does not have a position on this, right? So this is really my personal and internal trying to juggle this, but I do not I get nervous when we hand over, actually exactly as Michael Gottheil is saying, when we hand over these decisions about what is acceptable political expression. And Birju, I listened to the BC formulation of there's a floor and a ceiling, right? And so that means that someone's deciding, what is within that margin. And one of the things I worry about, for example, is that, there are going to be things that our society very broadly condemns, Nazism and Holocaust denial. Everybody is going to try to find a way to say that is below the floor or above the ceiling, depending on how you define those things. And you're going to be able to disassociate yourself with that form of political expression in some way. And then we're going to have expression and political beliefs that I personally find deeply objectionable, that target communities that are the active target of very high level political discussions, right? So you think about immigration discussions that are happening in many countries. You think about some of the trans issues that are actively being persecuted by governments. And those are going to be tied to political parties, right? And there are also political parties that are going to be tied to white supremacy, but those are going to have roots in more formal structures, and there is a real risk, I think, that you're going to say, yeah, those political views are going to get protected in ways that other political views are not, and I think that is damaging to communities, and it bolsters those really what I think are reprehensible, personally, political viewpoints through the law. So I'm not convinced it's as simple as everybody should be the same and should be protected. Birju, I 100% see the real prejudice to Indigenous and First Nations people by that particular geographic distinction. But I appreciate having different approaches across the country because they give us different templates to look at and different things to think about. And I don't think necessarily that variation is bad, because I think there are a lot of different ways that a rights respecting democracy can approach these issues that all have benefits and drawbacks. So I kind of like having the variation to help me creatively imagine.
Yeah, it's Michael. So first of all, I have to say, I wasn't aware of the Ontario case that left open the possibility that communism could be seen as a religion. And I'm sure Karl Marx turned over in his grave when he read that decision. But no, I do think there's a particular challenge with political belief. And I do agree with Michael in terms there should be consistency in terms of coverage. I mean, each jurisdiction will decide matters based on, as Birju said, on its facts. But I think there's a feature about political belief or political expression that's similar to creed or religion, because we're talking about conscience, right? This is it generally, unless it's a political party or an organized religion, we're talking about conscience, and essentially what an applicant or a complainant's going to do is say is, I don't want to do X, or I want to do Y because of my consciously held belief, right? And that's pretty broad. And if you look at the religion cases, the courts, yes, they struggled with that in the sense that, one of the seminal cases is Anselm and the Syndicat Northwest from Quebec, and it's, they said it as long as you have a firmly held belief, a firmly held good faith belief. I'm collapsing, but then it's a religion. You don't have your beliefs and the tenets don't have to coincide with others who claim a similar religious belief, right? It just has to be so. So in that case, it was a Jewish individual, and the argument was, well, not all Jews want to put up a sukkah, on their balcony. You don't have to do that to be Jewish. And the court understandably said, well, that's not the point, right? So it has to be commonly, it has to be, you have to, a firmly held belief. But what they do, they still went on and say, it has to relate to sort of a concept or related to a divine or spiritual realm, which is similar to this thing about political belief. It has somehow related to the social structure of society. And I think that's where, again, the courts or tribunals often run into trouble because, again, you're somebody say, I hold this belief. It's a firmly held belief, and I don't want to do this or I do want to do that. And over the years, I've come to think, reflect that in the charter we have Section 1, right? So the court, I mean, some people may like it or not, but what happens is the court's able to say, yes, that is a human rights, but given, is it justifiable in a free, is the limitation justifiable in a free and democratic society, which can address things like, yeah, you still have to wear the mask, or you still need to get vaccinated, or whatever the case may be. You don't have that valve in human rights legislation.
Yeah, I think and maybe just to answer very briefly Michael Link's two-part question. I think that in principle, I would certainly agree. I would agree that it's challenging to have different definitions, like this applying differently across different jurisdictions in the way that it has. Strikes me as problematic for sure. And I think with the Canadian Human Rights Commission, I think the reason why, that sort of lacuna exists the way that it does is because it was a type of imaginative poverty, I think, on the part of when the Canadian Human Rights Commission came into existence. It was concerned with, the responsibilities with respect to the federal government versus provincial and territorial governments vis-a-vis the Constitution, right? Like, so the Section 91, 92 stuff. And unfortunately, First Nation individuals and communities kind of fell between the cracks, right? Because most federally regulated undertakings involve certain, business, and, we kind of remember these, like interprovincial trucking, grain mills and feeds and seeds, just stuff that usually isn't relevant to that. But I think it's the law of unintended consequences, which I think is almost a microcosm for the sort of thing, without putting too fine a point on it, that Abby, you and Michael G, you have raised is in some ways, the be careful what you wish for type thing. The devil is in the details, certainly. And so one of the issues is that balance between, you'll notice that the way that BC formulated what it did versus, what's happening in like PEI, which is far more restrictive, and whether or not, and Michael Link might be the better arbiter of this question as a matter of international law, do any of those comply with, international human rights law, which may not have those same limits. And so I think in principle, like, I agree with Michael Link. Like, I believe in the protection of political belief association activity. And I think also it's so important, like, a lot of this will either restrict or permit. It'll tell you who gets to participate in public life and society over others by virtue of that. But I'm mindful of, it's absolutely correct that security of tenure, those points that Michael raised, these are going to be people that are, appointed by the state. And therefore, in order to be there in the first place, there is a certain political purity test. I know a thing or two about that myself, but yeah, I mean, I certainly can't disagree with that. But yeah, I think it's a really important question Michael Link poses.
Thanks for that exchange. I want to turn to the definitional scope piece a little bit, and maybe push back a little bit on the link, the understanding of political belief being linked to conscience. And I wonder if really we're talking about different things in different instances. I mean, we've heard about a limited protection of political belief being restricted to political parties or political engagement, and that seems to me to be in a sense, the opposite of a conscientious view. And I'm aware of a case. I should have looked it up, but my view is I believe that it has not yet been decided by the Ontario Court of Appeal. A decision of a superior court in Ontario that was a charter challenge to the first past the post electoral system, in which the claimant is arguing for an analogous ground of political opinion under Section 15 of the charter, and the trial judge ruled quite firmly that who one votes for in an election is the definition of a mutable characteristic, and that could never, therefore, be aligned with the conditions of Section 15 recognition. To what extent? I mean, if the Ontario Court of Appeal upholds that decision, and I think it's anybody's guess whether they will. I'm very interested to see that decision when it comes out. But I mean, is anybody else watching that case? Does anybody else think that that might have any relevance to this discussion?
I mean, for sure, right? So for sure, in terms of the tie-in between our domestic law, our constitution, and the international law, how we reflect those international instruments, and also, so for me, it's interesting. It's sort of, I go back to that, why was it in the Universal Declaration of Human Rights in the first place? Like, what did they have in mind? And I would love it to be part of the charter, I will say, right? I think that. But I'm not sure. For me, it's the same type of discrimination in that view of it. I'm not sure it's the same type of discrimination that we typically see under Section 15. Right? It's more about like persecution and just limits on expression and political belief in a way. So I think it'll be interesting, and I do think that, as Michael Link said, if that gets into the charter, it does open up more possibilities for end type analysis on the under inclusivity of the Human Rights Code as well. And I think other courts have. I think there's a court out east that already said it was an analogous ground under Section 15 too, right? So it's and we've got different opinions on it in different.
Although to clarify, both you and Michael Link are making the point, I think, that protection from religious discrimination is provided under Section 2, not Section 15 of the Charter. And I think
both. It's actually religious belief is protected both under
theoretically
Section 2.
Okay, I'm mindful of the ticking clock, and I wanted and of our audience. Although we can't see you, we know that you're there, and I'd like to turn to Ange to introduce questions from our audience. Ange, if you would, please.
Yeah, and I do want to remind attendees that you can use the Q&A button if you'd like to ask a question. The first question is, if there is a broad protection for political belief, opinion, and expression in human rights law, as in BC, does that mean that our public library cannot refuse to hire someone who, although otherwise qualified for the job, is an open white supremacist?
Sorry, could you repeat that question? You cut out just at the end of the question on my end. Sorry.
Oh, did you? Okay, so if there is a broad protection for political belief, opinion, and expression in human rights law, as in BC, does that mean that our public library cannot refuse to hire someone who, although otherwise qualified for the job, is an open white supremacist?
Mind if I jump in on that? Maybe to start with.
Go ahead.
So I think one of the things to note is that when it comes to, and very quickly, and this is going to be very trite to everyone on this panel, but the test, as to whether or not you have a human rights complaint anywhere in the country is basically the same. It's, do you have a characteristic protected under human rights law? 2, have you suffered adverse treatment or impact? And lastly, is the protected characteristic a factor, right? So once you've established that prima facie case of discrimination, the burden then shifts to the respondent, right? And the respondent can say, I did discriminate against this person, but the discrimination was reasonable and justified. And then, of course, they'd have to make a case for it. And so the Supreme Court of Canada in Miorin makes reference to one of the things when it talks about what's called a bona fide occupational requirement in the context of a duty to accommodate. It says one of the things that you can consider is morale. So if it's quite possible that an employer can say, look, if we have a diverse workforce and we hire a white supremacist, the workplace is just going to be unmanageable given how anathema white supremacy is in our society. And that could be a very viable defense to a claim of discrimination in the first place. So it's quite possible that, and by the way, this is of course legal information, not legal advice, but hopefully the questioner is not in that position and is taking notes for that reason. But there are defenses to the problems, the problem of hiring a white supremacist. I don't think you'd be required to do that. I don't think you'd be stretched that far.
Does anybody see that as a cost that
yeah, it's Michael. So Michael Gottheil. So it's it's an interesting question, and I think does highlight again a difference between something like political belief and other grounds like disability or race. So because when tribunals do from time to time get complaints of essentially reverse discrimination, it's often called, right? And many cases, say, look, the Human Rights Code is there to protect the traditionally disadvantaged and marginalized, right? It's not a tool to give more power to people who are privileged. And so it's really focused on addressing discrimination of marginalized groups. So that's not unfrequently the way a human rights tribunal would address something like that. But what do you do when it's political belief, right? The white supremacists could say, well, we're traditionally marginalized. It's only recently we've been allowed to march in public, so anyway.
Awesome.
And the other thing I think that lent, so I think Birju's right. There'd be a defense you could raise, but it also means that any other groups that are really being quite repressed by broader society. So leave aside the white supremacists and think of your, the cause for you that you think is hard to speak about, but really important in society. And if you speak out about it, you are going to get social media bombs on you, right? That person may not get protection either, because that may cause all kinds of turmoil for the organization and morale problems. So it really, and maybe that person is the person that needs the most protection in the sense of being able to express a contrarian view that you actually think is important and you actually believe in and you actually think you need to speak, that truth to power. So again, the reliance on the turmoil and the morale of the institution that you're trying to enter or greater society, it opens it up to majoritarian tendencies or loud voices in a way that is undermines some of the spirit of what I think the right would be trying to protect.
If I can jump in, I'm going through both human rights tribunal decisions and arbitration decisions involving expression of views. I think the law the law does make a distinction. It has made a distinction for some time between those people expressing political views that are advancing rights from vulnerable communities and those political views that are essentially repressing rights coming from the already privileged. And the law is sophisticated enough in Canada and legal decision makers, I think, are sophisticated enough in Canada to be able to distinguish between the two. And, you know, in terms of, you know, a library, public library, looking at a preferred candidate who happens to have supremacist views, if that person keeps his views to himself or herself or their self, then, you know, I don't see why that person shouldn't wind up getting the particular position. If the person then uses social media to identify himself and expressing these views, and that in a way that ties that person back to their employment at the public library, then that's another matter, and that's what we would call off-duty conduct. That's bringing disrepute to the employer. And I can make a distinction between that and somebody advocating, I don't know, support for what's going on in Los Angeles over the last couple of days in terms of what's going on in the streets. And I think most legal decision makers could probably make that kind of distinction. So it goes back to the fact that, you know, speech has limits in Canada, whether under freedom of expression or under hate speech laws, and we can make those distinctions.
Okay, and
I'll take CCLA's perspective, right? So CCLA has a long history of saying that we should not be leaving those types of decisions to, you know, the hate speech provisions of the Human Rights Code, that those raise real concerns about limits on expression. So yes, we absolutely have limits, but I will occupy the CCLA hat for a minute and say we think the ones that exist raise similar concerns.
Mm-hmm.
Let's take another question, Ange, if you've got one.
I do. So the next question is from Anthony, and they ask, is it possible to challenge a statute as under-inclusive for failing to protect against political belief discrimination as infringing fundamental freedoms under the Charter, such as freedom of conscience or expression, using the Dunmore test?
And I would say yes. I mean, I go back, in fact, not to Dunmore, though that's a helpful case, but the Vereen case that I mentioned before, that if sexual orientation was found by the Supreme Court of Canada to, in looking at the PEI and Alberta human rights statutes, to be under-inclusive because it wasn't put in there when it was in most of the other statutes, then I say there's probably an equally, if not even stronger case for saying that the Ontario human rights legislation or the federal human rights legislation is probably under-inclusive for not including political belief, in part because it's anchored in international law, but in part because a majority of jurisdictions wind up having it. And indeed, I think there's also a potential charter challenge to the very narrow definition of political expression or political belief that's in, say, New Brunswick or Prince Edward Island, that somebody who came in who had been discriminated against, let's say in employment with respect to political belief, but wasn't tied to a political party, I think that they would have a better than even chance of making a charter argument that means that the PEI legislation is too unduly restrictive, according to the way in which the Supreme Court of Canada has told us we are to read human rights in statutes.
If I can just very quickly supplement a couple of things to what Michael Link just said. You also have in Alberta, back in 2017, the Elders Advocate Society of Alberta successfully brought a charter challenge because the Alberta Human Rights Act at the time had not included age as a ground of discrimination in goods and services and housing, but did include it in employment. And so that change came into effect in Alberta in 2018. So another example of, you know, which I think piggybacks nicely off what Michael Link was just saying. And just here in Ontario, Vander Putten and Sudeco Industries back in 2012 was the case that got gender identity, gender expression added to the Ontario Human Rights Code. So yeah, two potential pathways, or you know, two more.
Okay. Ange, can we get another question, please?
Yes. So the next question, you've talked about some of the pros and cons of different approaches to political belief and human rights law. Cutting through all the complexity, I'd like to ask each of the panelists, if they were an advisor to Ontario's Attorney General, what would you advise him to do regarding the issues of political belief? Leave things as they are, with political belief not included in the Ontario Human Rights Code, add political affiliation or narrow definition as it is in New Brunswick, or add political belief with the broad understanding it has in BC?
The latter. Which well, it seems to have been an undercurrent of what we were talking about. But that goes back to what I had said a few minutes ago. I think it should be included in all human rights statutes, and I think it should be given the same broad liberal reach, not unlimited, but broad and liberal, that other human rights enjoy in Canada.
Michael, so sticking true to my perspective, I would agree that they should add political belief and expression in the broadest terms, but also increase the funding to the Human Rights Tribunal and make sure people who are appointed are qualified.
Yeah, I'll very quickly say that I'm going to modify the question and add, because it ended with broad in BC, I'm going to say broader still in Yukon, because I have to represent my friends in Yukon, which is broader than it is in BC. But I think I would echo the two Michaels. I don't know what is the plural for Michaels, but yeah. But I would particularly emphasize the resource part. I mean, this stuff does, and I think Michael and I have been parts of the same ship in terms of trying to deal with immense backlogs in the past, and to think of adding more grounds. Yeah, you in Alberta, every person basically got the equivalent of $2 for their human rights. That was the budget. It's probably shrunk. So your human rights were only worth $1.50 in Alberta, which can't even get you coffee these days. But
So I'll fill the role of the conservative. I'd probably say no. Although you're forcing me to make a decision, but I really am honestly quite very torn about this. So, but I will play the devil's advocate. And here's the additional perspective I will throw in. So, one of the cases that I have been involved in my private practice was a creed claim in Ontario. So not political beliefs, but a claim on creed from an individual who had strong pro-life beliefs. And she was protesting on public streets at a university, and the student union counter-protested and helped organize counter-protests. And that led to, and there were other things involved, but that led to years and years and years of litigation over very complicated issues. But the other cost, I think, is watching people be dragged through litigation, right? Like that, there is a cost to the human rights machinery, but I am just not sure that litigation is a great place to resolve these issues and differences of opinion. And maybe if we had a different legal system that focused on reconciliation and dialogue a bit more, as opposed to taking oppositional positions. And ultimately the goal really of that was to get organizations or people to change their minds and to force them. And I just am not, I don't love that way of reconciling and coming into dialogue and differences for people who have really different opinions about what should happen in really important issues in society.
Okay, good. I think we've got time for one more question. Ange, if you wouldn't mind giving it to us.
So the next question, your discussion has, sorry. Yeah, your discussion has focused on the breadth or narrowness of how political expression beliefs are defined for the Human Rights Acts, from party membership to broad public discourse. But there is another dimension I'd like you to address, and that is how broadly or narrowly the protection for political belief is applied. Is it just with respect to employment, or should it be more broadly to services, goods, facilities, voluntary associations, contracts, etc.?
Okay, I mean, I think a couple of the panelists have touched on that. Does anybody want to take that on first?
I mean, I'll say it as my like nervous, internally conflicted self, I'm much more comfortable applying this to an employment setting. I'll say, and even an accommodation setting, than I am to a goods and contracts. And that's part of, my pulling back on what are the community responses that are often rallied when you have political opinions or speech that you want to respond to as a collective response. Yeah, Michael has something else to add.
I was just going to say, probably the classic case is the American case of the wedding cake baker, who refused to make, because of his political beliefs, a wedding cake for two lesbians who were going to be married. And I have no problem with. I mean, I think that's a case where the law should apply, and that's outside of employment. That's provision of services, and I don't think we'd have much of an argument if he refused to make a wedding cake for a Black couple that came in, or for a disabled couple because of their particular protected characteristic. And I apply that to political. That's a place where you can draw a line with respect to political beliefs, because you have two different human rights that are in conflict there. And I think in that sort of case, you should be leaning towards the right which protects, if you like, equality, rather than the one that furthers inequality.
Michael, what if I don't want to make a cake for Trump's inauguration? To pick, what about, should I don't want to support that political cause through my provision of services. That's not something.
But then you have to show me as to why not making a cake for Trump, is in fact, continuing or accentuating inequality. And I don't think that it does in those circumstances
because of his political beliefs.
Yeah.
Can I add something?
Yeah.
Sorry, because I think there also is a temptation to think in terms of service provision as, like something that you buy, or something that you purchase. Remember that the police are a service. Remember that, if we're living in the United States, ICE would be service providers. Schools provide services. Correctional officers provide services. So it's not necessarily like the low stakes voluntary interaction type of situation that people often think. I mean, again, if I'm denied service provision based on political beliefs, the service provider may not be a baker. The service provider may be a police officer. I think if we look at it that way, I don't know if that changes, our perspective on things a little bit.
Yeah, for me, this is a so I like incorporating into the charter. Feels great to me. Right, and all of those services you listed are government public services. And there's big businesses who provide really broad services where discrimination against political beliefs would be like, some social media companies, very, very impactful and very disruptive and very problematic. But the private sphere is diverse and multitudinous and is personal relationships and corporate ones too. Anyway.
Let's just hope that if the Conservatives win the next election, we're not going to have a bunch of private prisons like in the United States, and we'll be fine.
No practice.
Well, folks, just as things are heating up, apparently, we've got to pull the plug on this discussion. We've reached our maximum time, but I'd like to thank each of the panelists for joining tonight and for giving me the opportunity to moderate this very interesting discussion with people who I respect very much, and I've learned a lot from this. I hope our guests have as well. With that, I'll turn it back to Jim.
Well, thank you so much. I want to second your thanks to the panel, Faisal. I thought the panel and you did a superb job. I learned a lot about human rights law and some challenging issues. So thank you. And I want to thank the audience as well for joining us tonight. Excuse me. If you did enjoy this panel, you might tell your friends and colleagues about it. A video of this session will be posted on the Center for Free Expression website tomorrow. And the Center for Free Expression website is cfe@torontomu.ca. As well, we post some additional resources for those of you who are interested in digging into the issues that were discussed tonight a little more broadly. The panelists are going to suggest readings and blog posts or videos or other things that address some of the things that were discussed this evening. And so that will be posted alongside the video. This is the last of our events for the 2024-25 academic year, but we are going to post on our website a list of suggested videos from the 80 or 90 that we've done over the years that are particularly relevant on various topics, whether it be racism or whatever. So if you are looking for things to watch or look at over the summer months, you can check out the website to see some suggestions. There have been some really excellent panels, as this one was. So thank you to the audience for joining us. Go to the website, cfe.torontomu.ca, and we'll look forward to seeing you next time. Good night, everyone.